Hello, everyone. Can you hear me well? Just to say.
Perfect.
Great. So, hi everyone, one more time. So glad to see all of you, and thank you for coming here. And today we are going to talk about the MiCA's regulation. What is it, and what is on everyone's eye right now? So just give me a sec to show my screen. And then we will start, okay? Can you see it now? Yeah?
Yes, everything perfect, thank you.
Okay, great. So, okay, so what is the MiCA regulation? So that's the main thing here. The introduction. MiCA, it is the first legal act in the EU that created the regulation for markets in crypto assets. Yeah, you understand that. And so we've been knowing about Bitcoin from 2008, yeah. But now, finally, 2023, they adopted the regulation. Thanks to God. So, and now we need to understand what we should expect from that regulation. Yeah, what is it about? And regarding the context, regarding the context of the regulation, and the same thing, we will structure also our discussion based on these things. The first thing is the scope of the regulation, something we should understand, yeah? And it is really essential to understand what types of crypto assets will fall under the regulation. And from that perspective, we will discuss them and to tell about some nuances, yeah? And also what market participants are involved and are covered under this regulation. Also, important thing, and moreover important, what requirements are set to them. And also we will talk a bit about the regulators and in the end, so be sure that you stay by the end, because we will also talk about the liability today. So interesting thing and so essential for you to know concerning the MiCA also. So just to understand regarding the MiCA, because we are talking, it was adopted and so on and so far, but we usually say will be, yeah? Why? Because it will fully apply only from December. It was already adopted as the legal act, yeah? But it will fully apply only from the December, but with two exceptions. We have two exceptions here, asset reference tokens and e-money tokens. And the sections regarding these types of crypto assets will be applied a bit earlier from June 2024, as you can see on the screen. And regarding while we are talking about MiCA in general, we really need to understand two main peculiarities about that. The first thing, it's that the regulation shall not be implemented on the national level, yeah. It is a regulation that was adopted on the EU level. And from that perspective, there is no need to have some additional national acts, yeah, because we know before the regulation will be applied, there are different separate national acts that are in force in different countries with some inconveniences between them, even, yeah, with different requirements. So it is not, it doesn't encourage the predictability of the EU market in general. But now it will be one basic regulation. And
so that I'm sorry here for cutting you off. So you mean that MiCA have a legal force now in each European Union member state, am I right? So that's the law. That's not the recommendation, not the approach. Yeah. That's the law. Okay, perfect. Thank you.
It is obligatory. Yeah, it is obligatory. Cool. And the nature of the regulation, unlike the directive, yeah, if you will speak about the directive, it should be implemented. It's also obligatory, but it should be taken some time to be implemented on the national level. But now, if we speak about the regulation, there is need for that. We just can take these norms and to follow the requirements set by them.
Okay, and, perfect. Thank you.
Yeah. And the second thing regarding the MiCA's regulation, the peculiarity of that is its extraterritorial effects, yeah? Also, we should know. So a little bit later, we will discuss the requirements and also we'll discuss the need of authorization. But for now, what I want to say, that MiCA made a step forward. Why? Because it provides an opportunity to obtain an authorization in one member state, and then to provide services or to issue offer tokens in all other EU member states. So there is no need to additional authorization, you see? And that's really a huge
Could I
step.
also cut you off a little bit, so, and just ask you, so, but if we're talking, for example, about the overseas company, imagine I have British Virgin Islands based company, token issuer, so, and I want to approach European market. So do I need to be in compliance with MiCA in that case? And do I need to have some specific authorization in European Union?
So I will try to answer this question because it's a rather interesting question indeed. First of all, we need to pay attention to the provisions outlined in MiCA, and they are stated that in case you are targeting on the audience inside the European Union, you shall have the authorization. But also, so such a definition, it may have rather broad sense, and in such case it is necessary to pay attention to other different like clarifications provided by ESMA in general, where it is stated also that in case we are talking about the situation when certain country targeting the audience in the European Union, it is necessary to understand the solicitation targeting as broadly as possible. And in case we're talking about the situation when we want to define whether the EU member, EU citizen finds some services, products, and use it on its own initiative. So in such case, it should be understandable, like as broad, as narrative as possible. So, and it's clearly stated that such situations, they shall be decided on case-by-case basis. But in general, what is provided as for now in certain like clarifications from ESMA, it is stated that in case you provide some marketing, some broadcasting, advertising, in case you use services of certain influencers, everything can be considered like you solicit the audience inside the European Union. Moreover, rather interesting topic here also, what if the customer use your services on its own initiative, and for example, you have stored the information about the customer in your database. So in case you store the information and later you will contact that customer, for example, to ask about other services which he may be interested in, or to propose something. So it also will be considered like solicitation of the EU clients.
In case you know that that person is European Union resident.
Yeah, for sure.
Okay, good. Thank you. Thank you for your answer. Thank you. Go ahead, guys. Go ahead. Thank you.
Okay, so regarding the regulation, the first thing, just to understand the logic of the regulation, what we need to understand. It is something that the MiCA is totally built on. And we need to understand the scope and particular types of crypto assets that falls under the regulation. So as you can see on this on the screen, yeah, there are three main types of the regulation that fall under its scope. And it is classified based on what risks they entail, yeah? It's based on whether they aim to stabilize their value by referencing something. So that is the main criteria for this classification. And from that perspective, we have, as I said, three main types. So the first type, e-money tokens. And here we should be attentive. It is a type of crypto assets that aim to stabilize their value by referencing only one official currency, yeah? E-money tokens, only one official currency. So remember that.
Official currency, I don't know, euro, US dollar,
yeah,
Polish zloty.
Yeah.
Okay, okay.
Exactly. But only one of them. The next thing, asset reference tokens. So asset reference tokens, they're similar. They also are asset-backed token, crypto assets, yeah? And from that perspective, it is a type of crypto assets that also aim to stabilize their value, but by referencing not only one official currency, as in case of e-money tokens, yeah, but by referencing a value or rights or a combination of them, yeah, including one or several official currency. So you see the difference, yeah. And this type of crypto assets covers all other backed crypto assets, yeah, with exception of e-money tokens and some exceptions that are particularly specified in the MiCA. So a bit later we'll talk about these exceptions. And the third type of the crypto assets, it's crypto assets other than asset reference tokens and e-money tokens. Yeah, a bit difficult to name. So let's make it shorter for this conference. Yeah, and set other crypto assets. Yeah, but we will know. Yeah, other crypto assets, I will say. And this type covers also all other types of crypto assets except the first and the second types, and except exceptions that are also particularly specified by MiCA. Yeah. So MiCA is about exceptions, so it's something we should also take into account. And from that perspective, also we will a bit later. I will tell you about these exceptions, but right now, what I want, I would like Alex to clarify a bit, yeah, to provide on some insights regarding specifically e-money tokens, and also provide on some examples regarding each three types of crypto assets.
Yeah, and after that, guys, also will come Lasky, so to explain to everyone. So from what I understand, NFTs do not fall into the third group, as I like in first and the second, but how they will regulate it then? So if they are outside of MiCA's scope, so what's the future for NFTs? So could you also tell us, please?
So yeah, for sure. Firstly, I suppose we can start with the e-money tokens. And in case we are talking about this type of crypto assets, it is necessary to consider that, as for now, there are no examples of such assets because this regulation is still not into force. And as a result, there are no issuers of such type of assets. So to understand the difference, the main difference, beside that, the e-money tokens, they are related only to the one official currency. Also, this type of crypto asset can be issued only by certain issuers with the specific requirements. For example, e-money tokens, they can be issued only by credit institutions or electronic money institutions.
Licensed in Europe.
Yeah, for sure.
Okay.
It's European Union regulation, so that's why, yeah.
Sometimes in general, it happens, I'm just asking.
If we are talking about this type of crypto assets, in my opinion, it can be something rather similar to CBDC, central bank digital currency. I'm not sure, and unfortunately, I can nothing for sure as for now about the future of this topic, about the CBDC in future and how it will be developed. But considering the information about e-money tokens as for now, the requirements to the issuers that it shall be only authorized institutions like credit institutions or e-money institutions, maybe it's some kind of early provisions which can be in future developed in some regulations regarding CBDC. So if we are talking about asset reference tokens, in my opinion, one of the best examples here will be stable coins like USDT and other ones, because as you know, for example, if we are talking about the USDT, so this stable coin is backed not only by US dollars, but also by US treasury bills and other assets. So that's exactly what we can see here, where it's exactly the same as the definition, because here we have a basket of assets, and such type of crypto assets, they are backed by them. So, and crypto assets other than above mentioned types of crypto assets, here we can, for example, say about utility tokens. I suppose it's like a general practice, because here we can see that there are no other certain descriptions or requirements or something like that. Considering your question, Slava, about NFT, I can say that MiCA exactly excludes NFTs from its scope of regulation, and it's directly mentioned in the provisions of MiCA. But NFTs, sometimes, and sometimes it still can be considered like, let's say, regulated under the MiCA provisions. In case the NFTs, for example, certain collections with a certain supply, but they don't have like distinctions, significant distinctions, and even we can say that, okay, but they will have a different token ID. Yeah, indeed, they will have that. But in general, in case we pay attention to the asset itself, there will be a lot of the same items in the collection. So, and also there are stated that in case it's some fractions of the NFTs, it also can be regulated under the provisions of MiCA regulation.
Okay, thank you for explanation. Great, everything is clear now. So with NFTs, everything depends on the nature of the NFT and the type. Okay, cool. Thank you very much. Maybe another question I want to ask you, if it's right time or not, but why doesn't MiCA cover security tokens?
So yeah, it's also a pretty interesting question, because first of all, the authorities here, they follow the next approach, which is also directly prescribed in the provisions of MiCA. There is stated that legislative acts on financial services, they should be guided by the principles of same activities, same risks, and same rules. So, and in such case, for sure, we're talking about the technology neutrality. So what does it mean? That in case you want to issue company shares, but on the blockchain or in any other form, but by its nature, this asset will be securities. So it's still securities, and the same regulations shall be applicable here. That's the first point. And also they're stated that in case, for example, something like tokenized securities or tokenized shares, it still shall be treated like the traditional financial instruments, and it still shall be regulated the same.
Got it. Perfect. Thank you for your answer. So, guys, move forward. I have no questions for now.
Okay, so then moving forward, so I think we're done with types of crypto assets, right now. And now let's move forward to the next question. So, what is our next question? It's the types of market players here and the main requirements. It is something that everyone is interested in, and something we also need to pay attention to. And what is said in the MiCA? And it is said that this regulation applies, and one more time, it applies to natural and legal persons, that are, and the first group, engaged in issuance, offer, or admission to trading, the first group, or provide crypto asset services. So they engaged in provision of the crypto asset services, the second group. And from the practical perspective, we understand that one group is just CASP, and or WASP is it is known in America, yeah, for instance. So it's a question of terminology here.
Not only in America, yeah. But
yeah, also like virtual assets. But MiCA operates with the terminology of crypto assets. And the next big group, it's offers and issues. And so just to understand why it is important, because there are different requirements to different market players, you see. And that's why it is important for us, firstly, to understand who is who, and then to discuss a bit regarding these requirements, so you may be aware of that, yeah? So that's why it's essential. And from that perspective, we see on the screen that crypto asset service providers, it's a legal person or other undertaking whose occupation or business is the provision of one or more crypto asset services, yeah, in the union. And on the screen, you may see the full list of such services. And just to make it much more clear, I would ask also Alex to clarify a bit regarding these types of services.
And sorry again for cutting you off. Yes, and I also think it would be cool to talk about this providing advice on crypto assets, because like very broad definition. And as for me, for instance, it's for example, if a law firm conducting a token nature assessment for the client, that means that that type of service is advice on crypto assets. So, for example, if you as a lawyer will do something...
Yeah, I got your point of view.
Okay, good.
But I have the question in return. Would you like to provide some financial advices or investment advices, or only token assessment, like, okay,
legal token assessment?
So, okay, in such case, it is necessary to pay attention to the definition provided in MiCA, and they're stated that providing advice on crypto asset, it's the offering, giving, or agreeing to give personalized or specific recommendations to a third party. And moreover, they're stated that such advice or recommendation shall be concerned the acquisition or the sale of one or more crypto assets, or the use of crypto asset services. So as a result, in such case, whether you provide only token assessment, like you try to estimate the potential nature of the token, its usage and activity which can be performed using the token, it shall not be classified like providing advice on crypto assets, because you not advise someone to buy the token, to hold the token, to invest in the product, or something like that.
Mm-hmm. Okay, thank you. Got it.
Okay, so, and that was the first group, yeah? The first group are crypto asset service providers. And the second big group you can see on the screen, it's offers and issuers. So you understand what does it mean, I guess. So, and they are also classified in MiCA into 3 subtypes, let's say, yeah, depending on the types of crypto assets we previously discussed. And the risks such crypto assets also entail. So, and you can see on the screen the main 3 types. So we discussed it already. And depending on the type, MiCA also sets the requirements, different requirements, because some of players have lower risks, yeah, and some of them high risks. And first of all, before we switch to the requirements, I would say a couple of words, just literally a couple of words regarding notable exceptions, what market participants will not fall under the regulation. And then we will discuss in detail, just in detail, a few things, yeah, regarding the requirements. And regarding the exceptions of market participants, what we can see that on the screen. And the first type is decentralized exchange, yeah, known as DeFi in public. The first type. And the second type, it's CASP serving, but what is important, it's an exception, yeah, CASP serving exclusively for their affiliates, for some internal reasons, aims, and or in liquidation or bankruptcy proceedings. And also, who falls under the exception, it's certain financial institutions, and public international organization. So it's also essential to take into account. And switching to the requirements. So at the beginning, I would say that it isn't possible to cover all the requirements for each market players, just limited by one workshop. That's why I just to make the main points, so you can understand the main tendency of the MiCA, and know what you should expect from that regulation. And from that perspective, I think it's reasonable to start from CASP and when to switch to offers issuers. So CASP, the main thing here, what we need to do for them is to have a registered office in the EU, the second thing, to receive authorization, and the third main thing, also essential, it's to have minimum authorized capital. So
here's very interesting point. So, and I don't see on the slide. Maybe you can share with us just what numbers we are talking about when mentioning this minimum authorized capital for CASP, for example, or other participants.
Got you. So regarding the minimum authorized capital, so, and if we speak particularly about the CASPs, so that will be the minimum capital from 50,000 euros to 150,000 euros. So such a limits. If we speak about other players, I will tell a bit later also to clarify that. But just to understand, the first group, three main requirements. So there are other also, but that's something you should remember about. And the second groups, offers and issuers. And again, what I previously said, that requirements are set depending on the types of crypto assets. And just the easiest situation, it's when we offer to the public the other crypto assets, this third type, In this case, we just need to have a legal person. By the way, I wanted to start from general requirements to all offers and issuers. It will be maybe more clear for you. General requirements for all issuers and offers. To have white paper, like technical documents, that will tell you about. I hope you know what is it about. So if need, just to write here, and marketing communications also, and be liable in case of providing the incorrect information in such documents. These requirements are general, are common for all offers and issuers, for different types. But what also there are some specific requirements depending on the type of crypto assets. I started to name them, and the first was about offers. One more time, legal person, only one legal person, offers of other than crypto assets. The second group, issuers or offers of asset reference tokens. And here we have additional obligations. So to have registered office also in the EU and to receive authorization. And one more thing also I promised to tell you about is that there is a requirement to minimum capital. And there are different options regarding requirements, depending on what is greater. And the first thing is fixed sum. It's 350,000 euros, or 2% of the reserved assets, depending on what is greater. So that is the requirements to offer.
So for that group, entry ticket is pretty bigger in comparison with just CASPs.
So a bit much more difficult situation, let's say. And also, if we speak about issuers or offers of e-money tokens, so the main obligation here is to be credit institution or electronic money institution. Yeah, specific kind of the most specific maybe kinds of crypto assets. Yeah, and specific requirements. So from that perspective, we discussed the main requirements. Yeah. So now you are aware of them and understand what to expect. And I guess that we basic things now, but also we have two additional topics. I also promised to provide slides about, yeah, and that is about the regulators. So who will keep eye on you in case you enter a EU market, yeah, and also about liability. So what, not you, not other market players, let's
Someone
say,
else
will expect, yeah, in case of violating the MiCA's provision. So, and here I also would like to ask Alexei, Alex, to clarify a bit regarding this topic, and then maybe we will make some conclusions regarding our discussion, yeah, and also provide us.
And I already have one question to discuss, but after Alex will tell about what he wants to tell.
Okay.
So yeah, in general, talking about the supervisory authorities, I would like to start that on the EU, I mean on the union level, there will be two main supervisory authorities, which is EBA and ESMA. So EBA, it refers to the European Banking Association, and ESMA, it refers to the European Securities Market Commission. Sorry, authority, not commission. So talking about the supervision and liabilities, first of all, it is necessary to pay attention that according to the MiCA regulation, each EU member state, they must designate competent authorities to enforce MiCA regulations, and such authorities shall be able to provide some investigations, in general, to have investigative and supervisory powers. Shortly about the competence of such authorities. So they shall be able to authorize crypto asset services and crypto asset service providers demand some information and some documents from them. In certain cases, prohibit crypto asset services upon the confirmed violations, especially, and public non-compliance, for example, by certain crypto asset service providers. So that's the general information. Also, talking about the power of the supervisory authorities, which is EBA and ESMA, it is necessary to pay attention that the main activity of these two authorities is to observe the compliance by the crypto asset service providers, issuers, and offerers, but also in certain cases they may conduct intervention where it is necessary, for example, to limit certain activity or to stop, to block them in certain activities, and such issues, I mean, such situations also outlined in the MiCA provisions. And I suppose here we can move to the information about liability.
Just one question regarding the regulators and enforcement processes. So for me, it's very interesting to know, because I have a lot of experience with European Union entities. At the same time, I have some experience with US-based companies and their regulations. So, and I'm sorry, I want to ask you, how will the European Union government protect European Union residents from offshore projects who didn't get an authorization? So just for example, in the United States, their Security Exchange Commission is very active when it comes to prosecution, investigations. So they're cooperating with FBI and other governmental bodies to find gauge violators. just in your like personal opinion, so will Europe be as active at the same level as the United States, or we will see just some kind of blocking projects on the internet service providers level, that is similar was done with, for example, 3 or 5 years ago with these unlicensed offshore casinos, and some kind of the same businesses. So just in comparison with US, what are your expectations? How European Union government will protect residents from that activities?
So as for now, it's rather hard to answer definitely for this question and provide a 100% sure answer, but still we can pay attention to the information provided in MiCA, and there we have even certain provisions which outline the communication between the supervisory authorities of European Union, ESMA and EBA, and between the supervisory authorities of the third countries. And moreover, such information also relates to the competent authority on the national level, because further, while we will talk about the liability, so you will see that first of all, national authorities, they have the power to like impose certain fines and administrative measures. So that's why we need to pay attention to this level. And
so we'll see later, am I right?
Yeah, for sure. So, and MiCA provides that the competent authorities of member states, they shall, where necessary for sure, conclude cooperation arrangements with supervisory authorities of third countries concerning the exchange of information with those supervisory authorities of third countries and the enforcement of obligations under this regulation in those third countries. So such, of course, cooperation arrangements, they shall ensure at least an efficient exchange of information that will allow the competent authorities to comply, first of all, with their obligations and duties under the MiCA regulation. Moreover, the competent authorities of each member state, while they want to conclude cooperation arrangements with certain countries' supervisory authorities, they shall inform EBA and ESMA about such decision. And also ESMA, in close cooperation with EBA, they shall develop draft regulatory technical standards establishing a template of such documents. So considering this information and taking into account the future development, maybe we will see something like exchange of information, detecting of such wrongdoers, and maybe there will be some actions, but it's rather hard to answer like 100% that they will try to ban them or they will prosecute them, they will try to fine them, and etc.
Okay, perfect. Thank you for answering. So, and maybe now I'll ask. Okay, let's move to the liability because we need to speed up. And after that, I will ask one short but philosophical question also to discuss with you. Okay, Anastasia, go ahead, please.
So, yeah, I will continue with the liability. And here, while we are talking about the liability, we need to pay attention that MiCA provides certain information about the administrative fines and administrative measures that can be imposed on the certain like crypto asset service providers who breach the regulators and the provisions of MiCA regulations. It is necessary to pay attention that not only administrative liability can be like impose on such actors, but also the civil and even criminal, because MiCA states that the information provided there about administrative fines, thresholds, and etc. It's, let's say, some kind of recommendation. But in general, there are stated that member states may decide not to lay down rules for administrative penalties where the certain infringements outlined in MiCA are already subject to criminal penalties in their national law. And in such case, member states who wants to leave the criminal liability, they shall notify MiCA about the, notify competent authorities about their decision. And they, I mean, such member states, they shall double check, let's say, that such competent authorities in their country, they have the full power necessary to comply and to enforce such type of actions. In general, if we're talking about the thresholds and administrative fines provided within the MiCA regulation, so there is stated that the infringement committed by legal persons, they shall be, I mean, that local authorities, national authorities, they shall be able to impose certain fines, and the maximum administrative fees, they shall be at least 5 million euros, or in the member states whose official currency is not the euro, the corresponding value in the official currency for sure. And also it may be 3% of the total annual turnover. In general, it can be, it can vary from 3% and up to 12.5% of the total annual turnover of the legal person.
It's like a kind of GDPR fines.
Yeah, pretty huge fines.
Okay, another question, very philosophical, I think, but try to share your opinion with us. Is the MiCA regulation positive or negative for the industry? What do you think?
So, in my personal opinion, it's positive, of course, because while we're talking about the development of the industry, where the industry players, they know definitely the rules, they know definitely what they can do and what is prohibited within the market. It will help to develop the project, the products, and the industry itself better, and with a clear framework. So that's the first point. And the second point, in my personal opinion, also, so it is rather better to have something certain than uncertain, because in case we have certain rules, even if we are not pleased with them, we may be not happy with such rules, regulations, and etc. But at the same time, we definitely know what we can do and what I need to be afraid of, or what I need to stop doing and not to be punished.
Nice take. Nice take. Thank you. Thank you. So what next? Do you have, guys, something to add about your topic, or we can jump to Andrew and Vlad?
Yeah, I just want to add my points regarding the MiCA. Is it positive? So, and then I guess we can switch to another topic. Yeah. So I totally agree with Alex from that perspective, and I should say that MiCA is going to make an impact on different market participants, really in different way. So if we look from the perspective of private investors, from the customers, they will feel much more protected, yeah, because they will be armed by information from the white paper, from the market communication. They will be paid damages in case of they were provided incorrect information, yeah. They also receive a right to refund in some cases, so they are protected, and for them it's 100% positive. If we speak about their main market players like CASPs, offers, issuers, and so on, so it's a question that is a bit unequivocal, of course, yeah, because on one hand, it is for 100% positive, yeah, predictability, transparency, and so on. From one point of view, yeah, from another point of view, we see lots of requirements that MiCA sets, yeah. So we need to have the registered office in the EU in some cases, not all the time for all cases, yeah, but sometimes. We also need to have a minimum capital. We need to obtain authorization, yeah. So that adds some complexity and even the cost to the business, especially if we are talking about small and new businesses. So, but nevertheless, you know, I totally agree with Alex that he said that it's better to know the rules of the game, yeah, and to know what to expect from the market. But also, what I want to say that it is not to receive it as it is. That oh my God, so lots of problem with the regulation and so on. There are lots of nuances and lots of exceptions also we may to apply. That's why usually as well, just to understand what is happening, yeah, with your particular business, it is really required to make a pre-analysis, legal pre-analysis, yeah, of the situation. And that's why before entering the market, now all of, not all, but most our clients here who want to enter the EU market right now, they come to us just to make this pre-analysis, legal analysis, and see what is their activities, if it falls under MiCA's regulation, yeah, what nuances, what exceptions may be applied, maybe to take our clients free of their authorization, yeah. That's why it's a really important issue. So you may come to us, for instance, or you may try to find another legal expert in this sphere. But what I'm trying to say is it's really important before entering the market, yeah. So to see what it is.
Thank you for your opinion.
Thank you so much.
Thank you, Alex. Thank you, Anastasia, for your speech. So let's move to another part of our today's meeting. We will discuss now with guys ICOs and STOs. So guys, please welcome Vlad, Andrew. Your turn.
Hello, everyone. Do you hear me well?
Yeah, perfect.
Yeah, okay. So let me share my screen. Yeah, you shall see it now.
Yeah.
So hello, everyone, again. My name is Vlad. Today with Andrei, we will try to provide you with insightful information regarding initial coin offerings, further mentioned as ICOs, and security token offerings, STOs, in Europe. So the main subject of today's session was covered. It was a MiCA regulation, and we will try to run through different requirements that are set before ICOs and STOs in Europe. So firstly, it is mainly the fundraising mechanisms, and we will try to make some presumptions. Andrew, can you please tell us about them?
Yeah, no, for sure. So it's crucial to understand that initial coin offering and security token offerings are about fundraising, and these mechanisms just leverage blockchain technology and cryptocurrency, but we intentionally narrowing down our focus to mechanisms recognized by the regulatory bodies, because such vehicles like IDOs, IEOs, ICOs, and stuff like that not widely acknowledged by the regulators, and usually they use definition of ICO, but we will use STO definition as exemption just for convenience to understand when we're talking about security tokens and for utility tokens.
Yeah, great. So for this session, we are presuming that some STOs are ICOs. Since you can address to ISMA's consultations, European Security and Market Authority, where they are telling us that they are providing ICOs definition, but are not using any other ITO, STO. So you can see on this slide, on this scheme, the controlling body's perspective for ICOs and STOs. So for the purposes of this session, let's define what is ICO and STO. So ICO is a process of a company issuing and selling digital tokens to an end users. Mostly, it covers utility tokens. Such will provide different rights to such users, like access to platform, to services, or products. On the other hand, we have security token offerings, such as an issuance of tokens that are deemed securities. In most cases, such security tokens, they grant rights similar to bonds or securitized debt or shares in the company. So both ICOs and STOs are fundraising mechanisms, and we will discuss further how they are regulated and how controlling bodies are understanding them. So let's delve deeper into understanding of these processes and what requirements you shall comply with. The primary regulations addressing ICOs and STOs in Europe are MiCA, as we covered previously. We shall remember that such is only a proposed regulation, but it can have implications already to the existing businesses. But unlike MiCA, that is only a proposed framework that will yet to become, and very soon it will be effective. Markets in Financial Instruments Directive, MiFID II, is already existing framework, and such MiFID II, it covers security tokens. So you shall already be compliant with MiFID II if you want to issue security tokens in Europe. It is really essential. Furthermore, directive is not equal to regulation. As we can see, MiCA is regulation. So it is imperative for all the member states of European Union, unlike directive. But directive shall also be incorporated, but requirements can be less strict or more strict. We have an analysis by ISMA regarding which countries have stricter or less strict requirements, and 16 countries out of 27 of member states, they have the same legislation as in directive, so they just incorporated it. And 11 countries, they have either less strict or more strict requirements. You can address to ISMA's consultation to see which countries provided such information. So, Andrew, can you please advise us whether businesses shall comply now with MiCA?
Yeah, for sure. It's essential to understand that, however, it's just a proposed legislation. It's already there is a time frame when it should be enforced. One part shall be enforced from June, and second part shall be enforced from December. But even before that date, some countries like France, for example, which leads the EU in MiCA implementation, already created inside of their home legislation MiCA-like regime. So they already incorporate the norms that we see in MiCA in their local legislation, and even tried to even started to provide authorization to different market players under this MiCA-like regime. So, for example, as G-Forge already got an authorization from the French authority to work especially. So that's why we shall understand that it's this regulation will be in future, but it's inevitable that it will be. So there is no chance that it will be stopped or stuff like that. So we need to be prepared for these norms already.
Yeah, great. Thank you. With that in mind, we shall review which requirements are set by MiCA. So already existing businesses can already adjust their business processes to be compliant with MiCA. So first of all, and the main requirement is mandatory white paper. You can see detailed content which shall be provided in such white paper in Annex 1 of MiCA. And briefly saying, it includes details on the issuer. So you shall provide such information as legal entity which issues tokens, legal address of such, project information, offer details, crypto asset specifics, any risks included in it. Also, you shall provide rights and obligations of holders. And very important thing here is environmental impacts. So most businesses, they can already review their approaches regarding consensus utilization, whether it is proof of work or proof of stake, since there are different discussions in the European Union regarding negative impacts of proof of work consensus. So it can be wise to transfer from proof of work to proof of stake consensus, like Ethereum did, for example.
Yeah, exactly.
I here, guys, want to ask you one question. So I see on the presentation that projects need to notify the authority and before the publication of the white paper. So from the practical point of view, so how we can do that? What's the process? Which authority I need to notify? So because we have now, for example, if I want to approach the whole Europe and whole European Union, so what's the steps? What legislators, how they see that?
Yeah, so basically, the MiCA states that you need to notify controlling authority in your member state, so where your company is established in the European Union, you need to notify authority in your home member state. Basically, the CLI mechanism is not provided for now, but I suppose it will be some kind of electronic evident, electronic facility where you can share your white paper with the controlling body. It's important to emphasize that this white paper shall not be approved by the controlling body. So you just need to notify the controlling body. There is no kind of authorization to be grant to the project after you do this notification. So basically just for the transparency, plus this white paper will be shared by the controlling body in your member state with other member states where you want to run your activity, plus it will be available in the general registry of these white papers across the Europe, so it will be created by ESMA. Plus, you will need to keep this white paper on your website of your project as long as you run this activity, as long as any kind of crypto assets issued by you are held by the public. So it's main point about the transparency of all this stuff. So you can actually, moving forward, developing the mind, MiCA even prescribe you to notify the controlling body about any changes in these white papers. So you will be in constant communication with the controlling body of your member state about the implementation of any changes into this white paper. And I want to emphasize these white papers should be shared with the controlling body in advance before you start the token offering. So at least 20 days. Plus, it's not only about the white paper as well, something new. because marketing communications as well will be shall be shared with the controlling body, and they want to see it for sure. And as well, they shall be used only when you post your white paper, and they should be clearly definable, and there is no misleading information for sure, and it should be consistent with the white paper. So this framework.
So OpenAI is not the best solution to create that document. Am I right?
Yeah. So,
of course, I love OpenAI solutions, ChatGPT, but not in that case. Yeah.
Yeah.
Okay.
So,
good.
Yes. So for now, all these things are done just to create some kind of transparency in the industry. So from MiCA implementation, there is no chance for projects to manipulate with the data in their white paper, in economics, in their marketing communications. All stuff will be backed. It will be archived, and anybody
all
can.
All records are tracked.
Yeah. So anybody can check if the project run as it was previously stated in the white paper. So is it fair enough to deal with a particular project? So let's say it for the transparency in the industry, which is essential for now, because for sure these changes shall not hurt any good projects, but only the bad guys who try to mislead the customers
and that's cool for industry. So yes, when we talked about is MiCA good or not, so it looks like a lot of positive moments here. Okay, thank you very much for your opinion. Let's move, guys.
Yeah, so developing the mind, actually, these requirements to the issuer of the utility tokens are not so strict as it seems to be. So there is no capital requirements and stuff like that. So you just need to notify the controlling body and do as you stated in these documents. Plus, as mentioned in MiCA, as we mentioned before, you will be in constant communication with the controlling body. So it's wise to have a company or in the European Union or a representation of any kind to deal with the controlling authority in a particular member state where you want, actually. Yeah, so, and for sure about the exemptions, because these requirements are not mandatory for the projects which are limiting their wishes to attract funds. For example, if project just want to raise 1 million euros over 12 months, there is no need to abide these rules. As well, if the project do just a private offering to qualify investors, again, you can do it privately without any requirements from the government. And again, something similar that we have with the fundraising directive, crowdfunding directive, and MiFID II. It's about limitation of 150 persons per member state. So if you limit your prospectus of offering to these numbers, you're free to go without compliance with MiCA.
Yeah, great. Thank you. So such were the main requirements under MiCA: white paper notification, white paper draft with the requirements under MiCA. Also, we shall remember that there are exemptions in place for white paper, so in some cases you don't need to have it. And of course, for the issuer of utility tokens, there is no requirements for any representative branches in Europe or legal entity. So let's, with that in mind, let's move forward. Now we will transfer to security token offerings. So the regulations of security tokens are very distinctive in comparison with utility tokens. So to understand if your token is security, you shall apply a test from MiFID II. It regulates that security tokens are financial instruments in case they are transferable securities. To understand if your token is transferable securities, it shall be negotiable on markets and shall fall under three categories: shares or equivalent securities in companies, bonds or securitized debts, or other securities providing rights to acquire or sell transferable securities. In most cases, controlling bodies can say that your token is fallen under third category, other securities. So it is wise to address to national legislation and also maybe apply for the consultation from consulting body. Since, as we were mentioning, MiFID is directive, and European countries can apply their own standards and their own provisions. So, Andrei, can you please tell us some examples?
Yeah, for sure. So basically, if we're talking about security, it's crucial to understand that if this asset can be traded on the market, is negotiable. So, however, to qualify as a transferable security instrument does not have to be treated only on the capital market. So, for example, it may include such thing like tokenized shares or bonds, for example, as let's say about Siemens AG that issued their bonds using blockchain technology and raised about 60 million euros during that procedure. So basically, to understand is it security or not, you should check the definitions that are in place in MiFID II. For example, like if you're talking providing some kind of voting rights or decision-making rights to the holder, we know that usually these rights are granted to shareholders, so it's important to understand what kind of rights you grant, because even these small thing can be enough to understand to consider your token as a security.
Absolutely.
Yeah, pretty easy and fair enough.
Yeah, and what is important here that you shall preliminarily assess your token by your own. And it is advisable, even by controlling bodies, that if you see, for example, as you can see on this slide, that your token is covered by transferable securities definition, or it has some red flags, then you shall address such to the controlling body. They can assess it and evaluate if such is covered by the national transferable securities definition. In most cases, there are different consultations from ISMA, for example, on the regional level, or by BaFin on the national level in Germany, which says that it is rather hard to make the standard and common approach on defining if the token is security, and it shall be evaluated on the case by case. So moving forward, if you can see in your token such red flags, then you shall prepare and expect that you will have to comply with the requirements of MiFID II, and most important, with the prospectus regulation. The prospectus regulation is regulation, so it is mandatory for all member states, unlike directive. So if your token is security token, then you shall provide prospectus. Prospectus, unlike white paper in MiCA, it shall be approved by controlling body. So let's take an instance. You are a Germany legal entity, and you want to issue security token. You shall to draw up prospectus and apply to BaFin controlling body and obtain approval from them. Not only shall you notify them, but you shall to get an explicit approval for this prospectus. So regarding prospectus, there are different requirements for the content, and each shall include legal entity details, legal entity name, type of it, address, and etc. Moreover, it shall include different disclosures. It shall disclose the risks of holding such securities, rights and obligations of investors, any other disclosures and disclaimers, and provide explicitly what investment returns and profits they may expect from holding such securities. And everything everything will be assessed by the controlling body and approved or disapproved. Moreover, there are no authorization or registration requirements for the company wanting to issue security tokens. There are some additional requirements for transparency for the companies wanting to trade on capital markets, on trading venues, and transparency.
Yes.
Moreover, there are different exemptions, like with white papers. Andrew,
yeah, exactly.
can you please?
Exactly, yeah. So basically, it's situation very similar with the MiCA exceptions. So again, if you're pretty small, you can be easily exempted from these regulation as well. So if you wish to get less than 8 million euros, you're small enough to be exempted. If you run just a private placement to qualified investors as well, you are exempted. And again, if you just limit your offering to 150% per member state, you get an exemption. And for sure, these prospectus requirements do not need it for those companies who just need to create some kind of employee stock option schemes and stuff like that.
Yeah, and here it's very, very important to see that line between, for example, private placement and public solicitation, global solicitation. So it's also like a very common mistake of a lot of entrepreneurs who are thinking that they're doing private placement, but not. So that's something you need to always consider with proper lawyers in jurisdictions you want to operate.
For sure, for sure.
Yeah, so to summarize, there are different requirements that are applicable to utility tokens and to security tokens. So we can briefly say that to utility tokens, it's the white paper that pertains to them, and prospectus requirements are set for security tokens.
Yeah, very serious
so
document, by the way.
White paper is needed to be notified to the controlling bodies, whereas prospectus shall be approved by such controlling bodies. So let's move forward. We can see some recommendations for the companies that want to be sure that they have exactly utility tokens. Since to qualify under security tokens requirements, it is rather easy, and most of businesses, they want not to fall under such category. So we can advise that for your token to be considered utility in the European Union market, you shall cut off any profit expectations that your holders may have. You don't have to promote that your token will bring them investment returns. Moreover, you shall wisely assess your token features, so it is utility and, for example, provides some services, provides access to platform or to products, and not brings some profits. Moreover, you shall be consistent in communications. So in any communication channels, rather if it is your website or if it is your blog, you shall not say that such utility token can bring profit to your holders, since it will be evaluated.
That's the second common mistake with all of the projects. I think.
Yeah. So it actually is evaluated by controlling bodies, and it is a very good evidence that may tell that your token is security. Moreover, you shall be very cautious with assessments of your token. So most of issuers, they know that there is a Howey test, the US standard for determining if the token is security. It is not applicable for European Union region. So you shall not apply Howey test to determine if your token is security or any other tests of other jurisdictions. You shall apply or address this question under MiFID II and its definition. And as we said, the most crucial question here is if you promote that your token can bring a profits to your holders or not. So under such recommendations, you may assure that your utility token will not be deemed a security. So let's move forward. And so usually there a preliminary roadmap that may help you to issue a token. Andrew, can you help us?
Exactly. Yeah, I just want to add that all this stuff is not legal advice. And as the Vlad mentioned before, there is no particular test in the European Union that can clearly state that this token is security or not. So everything shall be taken.
Yeah, moreover, I want to add that about this case-to-case approaches, because almost of European Union countries are non-common law countries, so that's why there are no court precedent-based systems. So that's why that's not an advantage of European legislature. Most of the countries, but anyway, we need to deal with that, and we are happy just to share the information with you.
Moreover, let's reiterate that it is a directive, and 27 member states, they may have their own requirements. So it is very crucial.
Yeah, exactly. So considering these, the first thing you need to do to understand if your project is planning to raise some funds using ICO or STO, even maybe, to understand what exactly a token is. Try to understand, and although its features, rights, it will provide to holders functionalities that is will be used, which the token will be used and stuff like that. So it's important to understand what exactly a token is, and after that you can see if in the MiFID II, if there is any potential differences between definitions there and your token, and for sure you need to use potential exemptions to not to be covered by the MiFID II. And again, after that, it's important to understand how you plan to offering your tokens, so utilize the proper offering documents to cut off non-EU jurisdictions, because again, if you in compliance with MiCA, it is not 100% guarantee that you're in compliance with any other law outside the European Union. So if you want to be protected from this side, you need to limit your offering just to European Union.
And sometimes not only by the IP address of your customer or user, but with proper KYC actions. Because just cutting off an IP list of IP addresses, for example, from the United States, is not enough to be in compliance with also extraterritorial laws of United States.
Exactly. Yeah. Usually during the second phase, you should utilize the proper instruments to run KYC of your customers, to implement proper anti-money laundering procedures into your business, so you can for sure identify the risks and actually verify your customers from which country they are, and if there is no sanction list and stuff like that. And as mentioned, Slava, the IP ban based on geolocation is not enough to run this stuff for now. And for sure, you need to understand if there are any chance to limit, for example, transferability of the tokens. So for example, if your token is clearly a security, you can play with the different features of different definitions from the MiFID II to limit, for example, transferability of tokens by smart contracts. So it will be no negotiable and not be traded on the capital market and any market actually. And again, it's a good point to be out of the regulation of MiFID II. And for sure, during this phase, you usually starting to prepare proper documents to for your website and for your offering procedures and stuff like that. For sure, as a third stage, you usually need to consult with the controlling body because a lot of them are well, very pleased to help the good projects about the trying to reach the market. So for sure, they may help with the qualification of tokens and
yeah, some of them just from entrepreneur point of view, some of them have very attractive sandbox regimes, so
exactly,
from which you can benefit.
Yeah, so it's important to know that you are not the sole player, and you can easily ask for help from different sources, like controlling bodies or community, actually. And it's important to understand that after the ICO, there is no starting compliance. So you need to be in compliance for all the time you actually your token is accessible on the
and that
market.
literally is third common mistake, yes, because entrepreneurs thinking that, okay, first we need to fundraise, and after that we will come to consultants or somewhere to get an advice. It's not, it like too late. You need to do everything before, so that's the rule.
But for sure, you need to continue to be in compliance after these token generation events, one or two, and completely check any updates from the controlling bodies, from the code decision and stuff like that, to be sure that you are up to date, because everything changes. And we do not know, maybe there is some unit regulation next year, I would say, and the project need continuously assess the need of legal and regulatory adjustments as the project evolves, actually. Yeah, so usually following these steps, you may significantly mitigate the risks associated with the ISO, with STO, but again, it's not 100% a guarantee that all your project is risk-free. Anyway, so I suppose.
Okay. Thank you, guys. So important moment, just we're running out of time. So and what I want to propose as the next step. So instead of classic Q&A session, which is, first of all, is not our style of business, so it's very hard for lawyers to give proper answers during and after the 1 hour and a half webinar. So it's not the best. We are taking care about our reputation, and we are not given advices in online regime. It's not our style of work. So, but what I want to propose. So now one of our colleagues, Andrew, will share. Andrew, please send your LinkedIn profile and email in the chat. Andrew Litvin, yes, please. And you can guys easily reach out to us via Andrew's LinkedIn or his email. I saw interesting questions there. Some of that questions are very easy to answer. So, and if it takes just a few minutes for us, so we will just reply you via LinkedIn or email on your questions. When it comes to more complicated issues, so what we can do here, so we have a very interesting approach with our law firms. So you can come to us and we can do a legal health check for a strategic session for your project. You will have around 1 hour or maybe 1 hour and a half with someone from our legal team, and we will talk exactly about your project and what we can do with it. So I see there are some questions regarding the Germany, regarding the exemptions. So please come to us. Andrew will help you with all of the appointments and arrangements of the meetings. So just type him something now, and that's it. What else I want to add? So thank you very much for being here with us. 1 hour and a half. As I said, maybe sometimes boring, but very, very important content for any blockchain entrepreneurs and lawyers. So yeah, thank you very much for your time. Thank you, guys. Thank you, Vlad, Andrei, Anastasia, Alex, for information you give to all of us. And see you soon, guys.
Thank you very much.
Thank you very much to all. See you.
Yep. And if someone from your teams or your colleagues on Freon Network want to take a look that webinar, so somewhere maybe I don't know where, maybe. Okay, you can address to Andrei, and Andrei will share with you the downloaded video of that webinar. I just need to figure out how we can share it with you, but just contact Andrei by his contacts, and we will set everything. So thank you very much.
Have a nice day. Bye.
Thank you. Take care. Bye-bye.